Welcome to the Solution Nation podcast. My name is Sean Snowday, and I'm the president of Solution Nation. Solution Nation is dedicated to providing a platform for investors to learn about Israel's most dynamic public and private companies. We interview lead venture capitalists, Wall Street analysts, investment bankers, and managers of incubators and accelerators. Today's guest is Shulamit Hirsch, who is the head of intellectual property at Technion. Now, venture capitalists and acquirers should conduct due diligence into the intellectual property held by Israeli companies. Shulamit Hirsch has a PhD in Technion's head of IP, and she discusses the following related issues: how to protect inventions during the research phase, avoiding entanglements with research sponsors such as universities, when inventors should seek releases from research institutions, when to file for patent protection versus maintaining trade secrets, how emerging Israeli companies can manage their patent budgets in view of their worldwide ambitions, and what happens to intellectual property sponsored by the Israeli government when Israeli companies are acquired by non-Israeli companies. Shulamit also discusses specific questions venture capitalists and acquirers should ask relative to target companies, prior art searches, patent assignment histories, claim coverage, and presence of patent continuations. Now, Shulamit Hirsch has a PhD and is one of Israel's leading intellectual property practitioners and advisors. She is head of the IP outsourcing at the Technion. Shulamit also consults with some of Israel's most promising private companies, Israel's largest public companies, and clients around the world, such as the Guangzhou Sino-Israel Biotech Fund. Please remember that all content provided on the Solution Nation podcast and website is for educational purposes only. Nothing shall be construed as investment advice. Investment decisions shall not be made based on information, written, verbal, or otherwise, posted or spoken on Solution Nation. Conduct your own research or consult with your own investment advisors before making investment decisions. So here's my good friend, the host of the show, and the CEO of Solution Nation, David Wanatik.
Welcome everyone to Solution Nation. I'm David Wanatik. Today we're going to talk about the importance of intellectual property and the role that IP plays in funding startup companies. Speaking on this issue, very pleased to introduce Shulamit Hirsch. Shulamit Hirsch is one of the foremost thought leaders in intellectual property in Israel. She's very, very accomplished. Just a couple of bullet points about her accomplishments. Shulamit is the head of intellectual property outsourcing at the Technion and does a great deal of consulting work for some publicly traded companies such as Cornet Digital, several privately held companies, and she's involved in many other activities, one of which is the Guangzhou Sino-Israel Biotech Fund. So Shulamit, thank you very much for joining us today.
Thank you, David, for inviting me.
So I just gave a very quick synopsis of your career. Maybe you can tell us a little bit more about what you do at the Technion and what you do for some of your clients.
Thank you. Yes. So for the last 2.5 years, I'm head of the IP at the Technion, and it's a great privilege to get to know so many exciting inventions and new ideas from one of the best universities in Israel. As you know, there are 7 universities in Israel and also some government and public research institutions, but I'm so glad to be at the Technion, which is one of the best research institutions in Israel. As head of IP, I'm in charge of evaluation and protection of new inventions, and also for prosecution and maintaining and being part of the licensing team at the Technion. And so I had some gut feeling for the new inventions, which are those that are worth protecting and which are those that will be successful in in the future in commercialization. In the past, I did a similar. I had a similar position at the Tel Aviv University, also as a VP of IP there, and also and did this role for many years. Before that, I also worked as a patent attorney, and with a background in chemistry, but one of the largest patent attorneys firms in Israel, which is Reinhard Kohn. Today, they split it in two separate offices, but then it was one office. So I had so I was trained there, and I worked there as a patent attorney for 9 years.
Okay. And how large is the tech transfer office at the Technion? How many professionals do they have?
There are about 12 professionals, out of which the patents team, it's 3 people. It's me and 2 paralegals. And all the other people are engaged with commercial business development, commercial accountants, legals. All those staff are. It's a small team, but very professional and very oriented in technological licensing.
Roughly how many inventions does the Technion patent every year? And roughly how many companies are spun out from the Technion every year?
It's a fluctuating number. I would say it's about 120 new inventions are submitted every year. Not all of them, of course, are protected, but something like 80% of them we are filing new provisional applications for all those inventions. Very interesting that during the Corona years we had more new inventions, so we had about 150, but the number is about 100, 120, and we have about at least something like 15 new startups, between 15 and 20 new startups at least every year from the Technion.
Okay, so Technion has 15 to 20 startups. And 100, 120 provisionals are filed in a normal year. What's the ratio of provisionals filed to non-provisional applications?
So after 1 year, you are meaning how many filing we have after 1 year, right? It's
So
about, because most of our filings are either US provisionals or Israeli first filing. And after 1 year, based on our evaluation of commercial prospects, we file about 60 to 70 complete applications. A large part of them are PCT applications in order to preserve the rights all over the world. And in some fields, we file only US complete applications.
Okay, so roughly half of the provisionals turn into non-provisional applications.
Even more, I think 60 to 70%.
Okay, all right. Now, it's amazing to me how you are the head of IP outsourcing at the Technion and still have time to do other consulting. Do you have subject matter expertise that you apply to all of your work, or is your knowledge so strong in patents that you don't necessarily have to have a strong subject matter expertise for all of the consulting engagements you take on?
So I was lucky enough to study chemistry when I was young. And chemistry is one of those subjects that are inter-technical. So they allow me to understand and handle as a consultant many technological fields like drugs and food tech and energy related subjects and material science, nanotechnology. But those are not all the relevant subjects. Therefore, I work with a team of experts that according to the subject. Sometimes I need biological expertise, sometimes engineering and software. So I have a team of colleagues that we work together when we have to deal with subjects that are not within my direct expertise.
Mm-hmm. Okay. All right. Good. That gives us a very much better background on your work. So that we can start talking about some of the issues. The theme of this session is to help the researchers better manage their IP budgets and better protect their inventions, and also with a view to those startup companies, those spin-off companies, help them manage their IP in a way that they'll be more attractive to venture capitalists and to acquirers down the road. So what recommendations would you give to a startup company that doesn't know much about IP, that's just starting to do their research? What should they do? What should they not do in order to protect the inventions that they come up with?
So I would recommend them to, first of all, not to publish their ideas before they are well protected. Because investment funds are like much more to have registered IP over non-registered. When I say non-registered, it's like trade secrets, for example, over registered patents. Therefore, it's better to have registered IP when startups want to talk to investors and raise money. Therefore, I would say that better to consult with patent attorneys from the beginning and build a strategy that is tailored to their needs. For example, if it's a startup in the field of drugs and pharma, and they started, the IP comes from a university, then I would say that first of all, they have to make sure that they have a robust license agreement in place, that and they have a license on the IP that they want to develop. If the license comes with some patent applications, then it's very important to continue to support those patents and make sure that they cover the subjects they develop. I mean, it's not justified to have patents that don't cover the product that it's in development. Therefore, if they come with IP from academia, it's very important to continue to support, continue to protect, and make sure that the IP covers the subject of the startup. If the startup doesn't have any IP, it's very recommended that they structure and they identify the core IP, and even if the budget it's low, they should discuss with patent attorney and protect the core IP, the core ideas, the most important aspects, and even if the budget is low, they can include in one provisional application as many subjects they want. Only after 1 year, after they did some more research and they are more focused on what they are going to develop, then after 1 year they can choose only maybe some of the ideas and continue with them with patent applications. But this is what I would say: cover as many as possible ideas in the new filings, and then after 1 year, decide which are your most important and continue to support them.
Okay, so just to highlight some of the things you said, you recommend that companies consult with IP attorneys, patent attorneys early. VCs appreciate registered IP more than non-registered IP, and very important that inventors cover the right inventions, the core inventions, preferably with patents. Okay, when researchers are doing the research, is it important that they document their discoveries, or is it not so important because most of the world is on a first to file system versus a first to invent system?
Yeah, so it's I think that most of the important countries are first to file. United States in the past was first to invent, but the law changed. Therefore, I think that it's very important to file as early as possible. Researchers in academia are well trained to register their data and findings. So this is not something that I have any say now. In the past, because I'm a patent attorney for more than 20 years, we did have issues with the documentation of data, and in a few cases we were successful to predate the date of filing to the date of invention. But these days this is less important, so I would say file first and take care of the other things later.
Mm-hmm. Would you also recommend that researchers don't disclose anything until they file a provisional, that they don't write papers and they don't make presentations about their inventions until they file provisionals?
Of course. As I said, they should the first patent should be filed before any publication occurs. This is part of our discussions with the researchers, and we ask them, please talk to us before you publish. And publication, it's not only the paper. It's, as you said, those are abstracts in conferences. Those are discussions, offers to third parties, and posters, theses of students. So everything like that is considered publication. Therefore, our goal is to file the patent before any publication occurs. But if nevertheless we are researchers talk to us after the publication occurs, this is not a lost issue, because in the United States we still can protect published inventions in 1 year after the first publication. Therefore, even if we are told that some poster was published or a thesis is in the library, we take the earliest publication date, and we know that from that date we have 1 year to file the provisional or US application. In the United States, there are additional countries, and this is the so-called grace period. So there is a grace period in the United States of 1 year. There are additional countries that might be of interest that also offer the 1 year grace or the half year grace. I would say Japan, Russia, and Australia, Canada are among those countries that give the grace opportunity to protect inventions even if they were published.
Okay. Is there any way to cure premature disclosure? So if a professor makes a speech or publishes something, is there any backdating of provisionals or any way to cure early disclosure before the provisional is filed, or is there's no way to cure that?
Not really.
Okay.
I would
Okay.
say only if the patent is filed on another subject, then that talk of the professor it's not relevant. But in most of the cases, there's nothing to do.
Okay. And did you recommend putting a big disclosure in the provisional, putting a lot of inventions in one provisional, and then making the non-provisional applications narrower? Is that what you recommend?
I would recommend for startups, yes, because in academia, usually it's easier. We have one invention in one provisional. But when startups are in the beginning that don't really know what is the best scenario, what is the best way to carry their invention, I would say yes. Include in one provisional as many ideas as possible, and after 1 year, they either can file a few applications from the first provisional, or only one with the best idea.
Mm-hmm. Okay. Is it better to put everything in one provisional? You can save a little bit of money. It's not that expensive to file a provisional. You know, why is it better to put everything in one versus having 3 or 4 provisionals?
Oh, it's also, of course, filing 3 or 4, it's of course fine and even better. But if sometimes, you know, the ideas are not so, it's not so easy to divide them even in 3 to 4 provisionals. And at least in Israel, inventors have so many ideas, and it's not so easy to find the 3, 4 umbrella ideas that can be included each in one provisional. So that's why I said maybe you can file one very big and then divide it in a few separate applications. Of course, if there is budget, file a few provisionals, and then you can continue with them. I would say that the amount of filings this is not the issue that will make an impression on the investors. It's better to show registration, and sometimes it's better to show granted patents and not many filings. If the investors uses a professional person that carries the IP due diligence, then that professional person will not be impressed of 10 provisionals on file, but will much more be impressed of sometimes one provisional and 2, 3 pending patents, and maybe one granted patent. And there are ways how to accelerate the acceptance of US patents. So they will make the IP due diligence more transparent for those that carry this process. So I would say file as early as possible. Make sure that you can have a granted patent, US patent, as fast as possible. And this will be helpful in the investing process.
Okay. All right. Let's go on to the next topic. Avoiding entanglements with sponsors like universities and incubators and government grants. This could be a huge issue, but what happens when Technion or another university spins out some companies? How can it be very clear to an investor or an acquirer of those spinouts that spin out and then the acquirer really owns that IP, and the university won't come later and say, we deserve a lot of money because some of our IP is in this company?
Okay, so first I would say that technology transfer offices in academia they are very I don't know if simple, but when they license IP to a new startup, the process is very clear. What does it mean? There is a license agreement that states all the provisions that occur on the startup. Therefore, all the commercial and legal requirements are there. I mean, there is not something that the university will come after 5 years and will require more money, because all the legal requirements are in the license agreement. And therefore, if an investor is willing to understand what are the requirements that the startup will be faced to, it's only to read the agreement with the university. Everything is there. Okay. Now about your basic question on sponsor, on founding with strings attached, right? So first of all, in Israel, the Israeli government is a primary source of R&D funding, and they provide financial support for a substantial portion of the R&D in Israel. The government the funding is provided by ministries of the government or by what is called the Israel Innovation Authority. The Israel Innovation Authority, also abbreviated IAA. So many startups and many research teams in academia, in hospitals, can obtain IAA funding. And the IAA funding for academic teams, entrepreneurs, startups, support very early stage development. And the goal of this funding is to encourage and promote the industry in Israel. Now, sometimes a very large amount of money are obtained from the IAA, from the Israeli authorities. However, sometimes when the startups become bigger, it happens that the research or the production or the entire funded startup is relocated outside Israel. In such case, there is a law behind the IAA funding. The law is called the law for the encouragement of industrial research. So the law is also saying that in case of relocation or taking out the research, there are increased royalties to be paid to the Israeli government. The increased royalties are, I think, up to 6 times the sum that was invested by the Israeli government, up to 6 times. Therefore, in this case, it's also a transparent situation over the Israeli government. What is the amount of money that it has to be paid back to the government in case of relocation? But in case that the startup remains in Israel, they don't have the issue of the fund payment.
So the 6 times, so you're saying that if a non-Israeli company wants to acquire an Israeli company that received government funding from the Israel Innovation Authority, the Israeli government would want 6 times their investment back, up to 6 times their investment back.
6 times, yes.
But if it's an Israeli company,
it's a thing of negotiations also with the Israeli authorities. Sometimes it's between 3 to 6 times.
mm-hmm. If it's an Israeli company that remains in Israel, what kind of return does the government want on that company?
I'm not aware of such return, but I think this issue has to be, checked with the authorities. I don't know.
Okay.
I don't have that.
Okay. So the issue with the universities, you're depicting it to be very clean. What happens if I do research at the Technion for 5 years, and during that time I file a couple patents, but not very many, And then as soon as I leave the Technion, I start filing a lot of patents and start my own company. And Intel buys my company. Is there still a risk that the Technion can come and say that David did a lot of his research at the Technion with our facilities, our equipment, our graduate students, and we think we own some of the patents that David filed the day after he left the Technion?
So it's a very good question. If David left the university, let's say, I don't know, it's a Technion or any other, and only really the day after he filed many patents, this is a problem. I mean, there's going to be a big problem if David's company will be successful and bought by Intel. And we have a few cases like that, not at the Technion, but I think there was a company, Omrix, bought by J&J. This company was from the Sheba Hospital. The inventor was a physician at the Sheba Hospital, and then the Omrix company was founded, and when it was sold to J&J, then the hospital came and said that he was supposed to get some of the royalties or the payments. So I would say that when David is going out and is founding a company and files many patents, if the subject of the new company is totally different from what he did at the Technion, I would say that in such case, his position is fine, and the Technion probably will not require any parts of his future company. But and usually it happens that the company is well related to the research that he did at the Technion, it's better for him to discuss with the Technion and make some commercial understandings, maybe a license agreement or something that will put his company in a very clear legal and commercial position that when he will be successful or when he will have shares, even if the Technion is supposed to get something, it's better that he finds this agreement from the beginning. Not when his company is successful, but from the beginning, he has this clearance with the Technion or any other university.
Mm-hmm. Okay, so the example of filing a lot of patent the day after one leaves the university, that's a little bit exaggerated, but if months and years go by and during that time I'm filing patents, is it possible to get a release from a university, to get a letter from the university saying that, when I left, everything was fair, that I have the right to continue doing my research elsewhere, and that the university has no claims on my future work?
Yes, I think it's something that he can obtain from the university. It will be relatively easy to get that letter if the subject that he will do in the future will be different from the research he did at the university. But even if not, approaching the university, I would say is the best, the more recommended procedure I will tell him to do. Instead of, filing and making a lot of developing something new and having that unclear point, better to have that letter or any understanding with the university from the beginning. Yes.
Okay. Yeah, I agree that it's better to get that letter if possible early. The faculty are friends with the tech transfer office. There's good camaraderie oftentimes between the tech transfer people and the researchers at universities. And the researcher may have some leverage. Maybe the researcher is needed to teach one more semester or to teach the new professor how to run the course. So they have some leverage. I would imagine if a university detected that my spinoff company, my new company is about to be acquired, and I need a letter at that point, they may detect there's a lot of money at stake, and maybe would a university charge me to produce that letter or ask me to pay to produce such a letter?
Well, it's such a theoretical question. It differs from case to case and from university to university. In Israeli universities or even each university in Israel may act differently. And so I would say my recommendation is to talk to the university from the beginning and don't hide the new startup or the new ideas. Even if they want a small share in the future company, it's better to know this if they want this. I don't know if they should get it, but it's better to know from the beginning than hiding, and then at the exit or at the more important stage, you don't want to have such surprises there. So I would say talk from the beginning. This is my simple recommendation.
Okay. Okay. So moving on to the next part, you mentioned that in many cases it's recommended that the IP be registered in the form of a patent, perhaps. But there must be circumstances where it makes sense to retain the invention in the form of a trade secret. So when is it appropriate to retain a trade secret?
Okay, so the simple rule of thumb is that if an infringement of the invention cannot be easily detected, meaning that the invention is not enforceable, you cannot see it in a product of somebody else, then there might be benefits to keep the invention secret as a trade secret. However, even saying that, even if a company decides to keep part of its IP as a secret, then it still should do steps to keep those assets, to keep them secret. What does it mean? I would recommend they document the secret like an invention. Write it down, explain it, put everything there, all the figures, all the codes, the software, it doesn't matter what, and then save it in escrow with one of his lawyers, for example. And by doing so, he will show that the invention, that secret, was well documented and well kept secret. Those are main steps that should be done when a company decides to keep part of its IP as secret, because one of my colleagues told me once, the secret goes home at 5 p.m. So you don't want the secret to go home, the employers go home at 5 p.m. You want to know that your secret is safely saved and safely documented. On the other side, yes, so if you cannot detect your invention easily in a product, then perhaps a part of it can be kept secret. However, if there are inventions in biotech, in pharma, in medical devices, food tech that are easily detected in a product, then I certainly say file patents.
Some people think that trade secreting is free, no cost. We can understand that patenting is expensive. We know what the fees are at all the different offices, and you need lawyers to do a lot of work. But maybe just say a few words about some of the expenses associated with maintaining trade secrets.
Well, maintaining trade secrets, I think it's really much cheaper than filing patents. You only have first time to write it down, and then keep it in a safe place, like an escrow. So those are relatively very cheap. It's very cheap. Of course, it's much more cheaper than patents. But when a VC carry IP due diligence before investment, and sometimes I'm part of such due diligence activities. So the investor will consider a company's registered IP in like patents or trade secret patents and trademarks and design patents in a much more. It will give you a much higher value and weight than only trade secrets. So even if patents are more expensive, I would say a company should have either both of the tools, but not only trade secrets.
Okay. I guess in the world of intangible assets, patents are perceived to be more tangible than trade secrets, because at least you get a piece of paper and a stamp.
Right.
But I think there are some costs for trade secrets. Sometimes you need to silo off who knows what. You only want certain people to know part of the process, and different people to know the middle part, different people to know the end part. You have to keep those people divided up, and maybe you need to make sure that there's biometrics in the laboratory to determine who gets access to which equipment and that kind of thing.
So you say that even in keeping the secret, it's also not a cheap process. All those steps that are required in order to divide the knowledge among people and make sure that not one person is aware of the. Yeah, you are right. Yes.
Okay. All right. So when you advise a young company, a early stage company, a lot of these companies rightfully have global ambitions, almost global ambitions, but they have limited budgets, especially in the early days. So generally, what kind of advice would you give them to protect their inventions at a reasonable cost?
Yeah. So okay. So I would say the core IP of a startup should be protected it's at least in the major markets. But the process is not, file the patents in all the countries from the beginning. There is a stepwise process. In the beginning, they can file a provisional application, so the cost will be only the very cheap filing and the drafting by a patent attorney. 1 year after them, they have the possibility to file an international PCT application, which is, again, not cheap. It's about $5,000 only the filing, and maybe some additional $5,000 for the additional drafting in order to make the PCT well described, well written. So with the $10,000, they file the PCT application, and they gain additional 1.5 years until they need to file the national application. So the PCT is like delaying the cost. And if the startup is going to raise money after 1 year, after 2 years, the PCT route might be a nice procedure to delay costs. sometimes startups file the PCT and in the US at the same time in order, as I said, to obtain granted US patents as fast as possible. This is a nice way to show investors and also to themselves that they have a robust piece of a robust asset. A granted US patent, it's a robust piece of IP. So if the budget is limited, I would say maybe go by this route, file provisional PCT and then national filings. All this procedure takes 2.5 years until the national filings is reached. At the national stage, I would recommend file in your major markets, at least in your major markets. United States first, and then you can choose additional jurisdictions. Europe, China, Japan, it depends on the field. I wouldn't say that a startup has to file in 20 countries, 15 countries, because this is really a lot of money. Focus on the most important markets where you want to have protection, and the less important inventions, you don't need to, I would say, there's no need to file in many countries, file only in the United States, which is a major market, at least 50% of the market in many, many fields. Therefore, the geographical coverage has to be decided with the business people within the company to make sure that you have protection in your major markets.
Mm-hmm. If a patent, non-provisional patent application is filed in the U.S., is it 30 months? You have to file it with a PCT within 30 months of the U.S.? Is that the rule?
You have to file the PCT in 12 months from the first filing.
In 12 months, okay.
From the first filing, yes. So if you file your first provisional in January 1st, 2022, you have to file the PCT until by January 1st, 2023.
But if I file the PCT in the U.S. and then file the non-provisional in the U.S. within a year,
no. If you file,
do I have more time to wait?
Yeah, if you file your first filing as a PCT, that's what you asked?
No, if I file my first non-provisional in the U.S.,
yes,
in the United States, so let's say that I filed my provisional last year, 1 year ago, and today I file my non-provisional in the U.S. How much time do I have?
You only have 1 year to file the complete application, meaning that if you file after 1 year your US application, this is also your deadline to file the PCT application. You don't have afterwards any more deadlines because there is a Paris Convention that says that you can file your first filing, for example, in the United States, but then you have only 12 months to file the complete application. You don't have. Okay, so it's only 1 year, the final deadline to file the complete application. The complete one, it can be a PCT or US or Europe, whenever you decide to submit. You don't have to file PCTs. You can file directly after 1 year in all the countries you are interested in. But the deadline, it's the same deadline, 1 year.
Wow, okay. All right. Well, I guess, you don't have to file in all the countries, not the very small ones, probably. I guess if you don't believe that a country upholds its patents, if you believe, if your analysis is that Brazil doesn't uphold their patents, then there's probably not a lot of reason to file in a country like Brazil, or if the pendency is longer than the obsolescence. So if your product is going to be good for 4 years, the life of your product's 4 years, and it takes 12 years for the Brazilians to make a decision, probably not a lot of benefit to file in Brazil.
Exactly. All right.
Okay.
Also, if your product is going to last for 4 years, the whole strategy should be changed, because you won't have a patent in Japan in 4 years, and also not probably not in Europe in 4 years. Therefore, perhaps getting the patent by the accelerated route in the United States. So in order to have a patent in 1 year, this might be the best way. If indeed the product is a tangible one and it's something that's worth filing the patent.
Okay. All right. The next topic, when an early stage company is doing a venture capital round, you mentioned that usually VCs appreciate registered IP, so that's a good thing if there's some registered IP. Do the VCs typically want the IP to serve as collateral? If the company fails, would the VC want to take the patents, or do they not? Do the VCs usually not require the patents to act as collateral for the investment?
Actually, I'm not so familiar with this issue. Usually, VCs are not the owner of the patents.
Mm-hmm.
Therefore, they don't really can replace the patents by money. The companies are the owners of the patents, and they can sell the patents and replace the patents by real money, or they can use those patents as collaterals for obtaining for going to the banks and obtaining loans and so on. But I'm not very familiar with this topic.
The VCs wouldn't know what to do with the patents if they took.
Right.
Okay. All right. I think we already discussed what happens to the IP when Israeli companies are acquired by non-Israeli companies. The government wants to make up to 6 times return on their investment.
In case of relocation of the company, yes. Not if the company remains in Israel. Right.
Okay. So, not exactly how that's defined. I don't know what constitutes being situated in Israel. A lot of times, big company acquires an Israeli company, but the research still stays in Israel.
So in such case, it is considered as it remained in Israel. If the research remains in Israel, I think it's considered as it remains in Israel.
Okay. So in that case, the acquirer would not be responsible for up to 6 times.
Yes, but it still requires, to discuss with the IAA, with the Israeli authority. I don't know what happens if the R&D remains in Israel, but the manufacturing, the production goes outside. So this is something, it's like something to double check with the authorities.
Okay. All right. So the last issue, maybe you can talk a little bit about IP due diligence and what due diligence do VCs do on the IP when they're considering making an investment? And maybe a similar question is, what research on IP do acquirers do when they're considering acquiring an early stage company?
Yeah. So I talked with many VCs, and there are many points of view. So there are very large VCs. They see more than 1,000 companies a year. So they will not carry due diligence on such numbers. This is clear. So but when what VCs are doing when they have a small number of companies that they are really interested to invest, then they carry the due diligence. And the due diligence will analyze, in my view, at least the way I do, at least three main aspects. There are formal aspects that include registered and non-registered IP rights, I mean, ownership of IP rights. Yes, check if the startup is the owner of all the IP assets or part of it's in license from academia or from a research institution. Yes, so find those ownership issues. If a startup has an exclusive license from academia, it's almost good enough as being the owner of that IP. I'm not saying that it has any lower value. And the status of the IP is still, I mean, number one. The formal aspects are locate the registered, the non-registered IP rights, the ownership, the status of the IP in the filing process, meaning if there are pending applications, granted patents, and so on. Check funding with strings attached, because sometimes there are types of fundings that there are strings. What does it mean? For example, if there is funding from European grants, so there are strings attached to this funding. If there is funding by the US government, like the NIH, DOD, they have also some requirements. Of course, the Israeli government also has some requirements. Therefore, all those issues are evaluated and known. The second aspect will be the coverage of the IP, scope of protection, geographical coverage. For example, if a JV is established in China, then I would look also to check if there are patents in China. And it's not enough to have patents in Europe and the United States if the main entity will be in China. Time to expiration of the patent. For drugs, this is it's a real issue. If the patent will expire in 5 years from now, and most of the chances that the drug will not be on the market within 5 years, then again, this is a problem to be aware of, that maybe the drug will not be covered by the molecule, the active molecule will not be covered by patents when it will get to the market. So the coverage, the scope of the coverage, it's very important. It's the second aspect to look at. And the third one is third-party considerations like licenses, freedom to operate, co-ownership of the patents. So those are the main issues to include in a due diligence process.
Okay. Do venture capitalists ask companies if they had conducted prior art searches? Do they?
Yes.
Okay.
They ask.
All right, good.
They ask, of course, and if they have, they can present. Having granted patents, however, is much more valuable than searches. So if a company has already granted patents, this is a presumption of validity. So it's much more valuable than searches and opinions by patent attorneys.
It's a presumption.
It's a presumption.
It can be disproved with the production of prior art.
Right, but yes, nowadays there are many IPRs and all kinds of steps that someone can invalidate patents in the United States. But still, having a granted patent is a real value.
Yeah. Okay. A couple of the things VCs may want to ask, you want to ask, were there prior art searches conducted before the filing? How rigorous were those prior art searches? Were they done by outside firms? Was it just Boolean logic or latent semantic analysis? So the rigor of the prior arts is important.
Yes, and having an opinion by a patent attorney on the prior art, even in freedom to operate, they are very very nice things that the startup can present to make the transparency and lower the risk for VCs.
Okay. VCs might also want to ask, look at the assignment history, number of transferences. The fewer, the better. As you said earlier, you want to make sure that the patents cover the important thing, the important invention. Sometimes companies might say, well, my VC wants me to get patents, so I'll get a patent. And it may not cover the most important thing. And it's good when there's continuations open.
Yes.
So the family can continue to grow and be tailored to what's important in the market.
Yeah.
All right. Well, very good. Any final words that you would like to say?
I think, first of all, thank you very much again for the discussion. And I think that I am a lucky person because my work is very interesting, and I'm familiar with many innovations and inventions and many interesting people that invent nice things. And I also am getting familiar with the years with the commercial aspects of those innovations. And so this makes the whole picture more complete, at least for me, when I evaluate things. So I have both the technological innovation and the commercial prospect in my view. I'm very happy to have this opportunity and kind of work.
Good. Well, we can tell you like your work very much because you're excited about it and you've dedicated your career to it, and you're extremely knowledgeable. So I'd like to thank Shulamit Hirsch for speaking to us on our podcast. She has a very, very strong background in IP, and this was a tough session. We talked about a lot of different issues, and patent law is very, very nuanced, and it changes, and it's different in every jurisdiction. So Shulamit Hirsch, I believe, is available for additional assignments and consultations. So whether you're an Israeli company, a young Israeli company, or even a public Israeli company, or you're a non-Israeli venture capitalist or non-Israeli potential acquirer of Israeli companies, and you need some assistance doing your due diligence on IP issues, Shulamit Hirsch has, I believe, some availability to take on a couple more clients. Shulamit, is the best website for you wipa.co.il?
No, actually, my LinkedIn page is the most updated one.
Okay.
I have an internet site which is Shulamit Hirsch .com. David, I forgot to mention one important thing, like a waiver that legal persons like to say that all those ideas and also those recommendations that I made shouldn't be considered legal advice. Those were general observations from my personal experience, and I always recommend people to consult with, IP lawyers, tax experts, all those professions that are needed when somebody invests or somebody acquires. Those are very complex issues, and expertise is needed.
Okay, good. Yeah, we put a general disclaimer before all the podcasts. So again, everything that Shulamit Hirsch said was for our general knowledge to get us started, to help us understand what some of the issues are. But if you need specific advice, either consult with Shulamit Hirsch or another very qualified IP professional. So anyway, I think we can end the session here. Thank you again, Shulamit. Very much appreciated.
Thank you very much. Thank you very much. Bye-bye.